look, marijuana on its own, he could be smoking marijuana all day long while he has those guns. But does it make him dangerous? Because that, according to this case, is where that historical analog for Bruin comes into being. We are the Arms Attorneys, and today everything's coming up green. We have two cases about marijuana, about whether or not you should be able to possess and purchase firearms while you are a habitual user. Stick around. We're going to talk about how these cases got challenged and what it means for you smokers out there. But before we get started, show your support for the Second Amendment by hitting the like button. And today's sponsor is Aura.
I don't know who our law partner Edwin ticked off, but he has to be on every telemarketer list known to man. It'd be funnier if it weren't true, but the pain and frustration in his face when his phone rings are really a sight to behold. It's taking years off his life.
One reason we all receive so many spam calls and texts is that data breaches are happening more and more often. Recently, there was a major national public data breach. The incident compromised over 2.9 billion records used for background checks, including critical personal information such as full names, addresses, dates of birth, phone numbers, and, most importantly, social security numbers.
Our community knows better than most that no one's coming to save you, especially the government. But you can be proactive with Aura, the sponsor of today's video. Aura has almost every internet safety tool you'll need all inside one app. Aura features a VPN, password manager, real-time credit and identity theft monitoring, internet parental controls, and protection for devices from malware.
These tools are crucial if you want to protect your bank account and social media accounts and other sensitive information. In addition to data breach notifications, Aura will remove your personal information from data brokers and people search sites that can sell it to identity thieves and scammers. Aura's always on provides incredible peace of mind with its 24/7 US-based support and does all the hard work of keeping you safe online.
Stop leaving yourself vulnerable to data breaches and take control of your privacy with Aura. Go to our sponsor, aura.com/armedattorneys to get a 14-day free trial and see if any of your data has been exposed. And what is very interesting about this, so these are two very recent decisions. One, and I think this made the rounds a little bit. It was the Fifth Circuit Court of Appeals. They sent a case back down to a district court as it relates to the prohibition on unlawful users of or people who are addicted to controlled substances. So we're talking about the prohibition under 18 U.S.C. 922 G3. Now, I think most people have heard about that, but we have a brand spanking new decision. This is a case that went up to the United States Supreme Court, Daniels. It got remanded back down to the Fifth Circuit, and this is a new case I don't think I've heard anybody else talk about. But this case is important because it's going to be our standard when we're reviewing, hey, look at this marijuana challenge. And so there's really a lot to dig into.
Oh, yeah. And it's funny because these two cases, although both expressly dealing with this marijuana provision, your habitual user of narcotics, of unlawful substances, including marijuana, they actually talk about two completely different facets of that. So it gives us a good overall picture. So let's start with Gill.
Yeah, Gill. All right. And if you want to check this case out, so this is United States v. Gill. And out of the Fifth Circuit, their case number is 2350525. If you want to check out, because this case ended up getting remanded to the district court, we'll talk about that. Their case number, it's out of El Paso. It's EP-CR00773-DB. Now, so what happened in Gill?
Well, Gill had a arrest in which marijuana was found, and he also had a firearm on him, and he was prosecuted under this particular part of the law. And his attorneys actually initially signed him up for a plea bargain.
Yep.
But took it back, clawed that thing back, and said, hold on a second. We need to do a Bruin analysis. We need to do a Rahimi analysis. We need to figure out how this now applies. And the district court, I think, initially didn't like it.
No, so he, asked for a motion to dismiss, basically saying, hey, this statute's facially unconstitutional, and it's as applied to me, it's unconstitutional. The district court didn't address the as applied challenge, and he appealed that up to the Fifth Circuit Court of Appeals, and there, using New York State Rifle and Pistol Association v. Bruin, using Rahimi, the court said, hey, guess what? You need to go evaluate this thing, hint, hint. Based on our cursory review of this, it doesn't look like there's a historical analog that would justify such an infringement. Go back and do it again. And we have this decision out of the district court now.
Yes. Now, so we've got these two challenges. We've got facial and as applied. So your challenge, your challenge to the constitutionality of a law, it is really awesome when you challenge and you say this is on its face unconstitutional, meaning there is not one scenario in this entire universe of scenarios in which this law could be upheld as constitutional. And when that happens, that is fabulous because it comes down. The law comes down and it's great, but courts hate to grant facial challenges. Why? Because the law comes down. I mean, the courts are like anybody else. They don't like to make the waves. They don't like to make the headlines, right?
No controversial decisions. Although I will say, to a large part, federal judges insulated from that, lifetime appointments with, as long as they're on good behavior. So they do it a little bit more, but it's very rare.
Right. So you are more likely to have granted your as applied challenge, meaning as to me specifically, in this specific set of facts, this law was unconstitutional. And that's what we have actually in both of these cases here. Still good, not as good. We'll talk at the end about whether we think marijuana is ever going to hit a facial challenge.
Yeah. So what happened? All right, Fifth Circuit said, go back, try again, evaluate this, facial challenge. And that's what we have out of El Paso. They said, hey, guess what? Under the scheme under which we judge Second Amendment infringements, this is unconstitutional as applied to Gill. Therefore, they ordered his indictment set aside, dismissed, conviction vacated, and they did it with prejudice, which means theoretically the case is over. However, and there's two steps to this, and that's what is going to make this so interesting. Can the government appeal this?
The government can appeal this. So that's really unfortunate. That's something in the federal system that is different than, say, our system here in Texas. And there are exceptions to this, but I would say broadly, when the government loses, they just got to take the L. And that's great. Idea being, once you have lost the government, it is not worth the taxpayer dollars to appeal it. It is an abuse of your power to keep this person in the system once they've been acquitted, once a certain number of things have occurred. You don't get to appeal. You don't get to keep it going. So that's good. Federal government, much more abusive of our rights than many states, as you may well know. And so the government can appeal, but they're going to have a hell of a time because they did not in any way prove that Mr. Gill was dangerous. And that's the key here is, look, marijuana on its own, he could be smoking marijuana all day long while he has those guns. But does it make him dangerous? Because that, according to this case, is where that historical analog for Bruin comes into being. Right?
Yes, and so when the government appeals this decision, which I fully anticipate they're going to do, we just got hit with this second whammy, the Daniels case. We'll give you that citation, United States v. Daniels, and out of the Fifth Circuit, its case number is 22-60596. This actually got remanded out of the United States Supreme Court, and they sent it back down to the Fifth Circuit to evaluate the same provision of law. And so whenever this district court opinion gets appealed, this dismissal gets appealed up, they're going to look and say, hey, did this lower court abuse its discretion when they found that, hey, facially this statute was unconstitutional? Well, guess what? They just issued their own opinion about what they think about this statute, and I don't see them meeting that standard.
Yes. So when the government appeals this to the Fifth Circuit has this beautiful case that should guide them. This is another marijuana case, and it is one in which the issue was not dangerousness, but temporal proximity. So this rings Hunter Biden to me.
Yeah.
Because what we've got is this idea. So Daniels gets arrested. He's got guns on him. He goes down to the station. He spills his guts. See recent linked video about why you do not do that. So he spills his guts, and in part, he's like, yeah,
I'm a habitual user.
Yeah, I'm a habitual user of marijuana. And so obviously the government's like, aha, we got you. And those are, I think, in government world, I mean, they pick and choose what they want to prosecute, and they do it based upon ease. And that seemed like an easy prosecution. I mean, he admitted it.
Yeah.
right?
He said he'd been smoking since high school,
Yeah.
smokes like every other day.
Right. And I think they actually had him say the words, I am a habitual user.
Yeah.
So I think they thought, bingo. Um, However, the court looks at this and says, wait a second. He wasn't high when you arrested him. He didn't have marijuana on him. What what does habitual mean in that circumstance?
Right. And so they took it into the context, again, back to New York State Rifle and Pistol Association. If we have a law that is touching what is covered by the Second Amendment, presumptively unconstitutional, burden over to the government to demonstrate based on the text of the Second Amendment as informed by history or tradition, that this is something that the government could legitimately regulate at the time of the adoption of the Second Amendment. And we get some new language in this case that I think is extremely instructive, not just for, marijuana cases, but if I saw other courts apply this kind of, hey, when we're looking at these historical analogs, because the Supreme Court in New York State Rifle and Pistol Association say we don't need a dead ringer, but it has to be analogous. Well, we kind of get from this the factors of what is analogous and what is the court instructing the government to kind of pick apart.
Yeah, so I like it. It's almost like a layman's sort of approach to it in the way they're articulating it. But they want two steps, after you've said, okay, Second Amendment applies, they say, okay, your historical analog needs to satisfy two things. It needs to satisfy the historical why and the historical how. And I'm just going to read this to you because I think it is very well articulated. So we've got the challenge and historical laws are relevantly similar, which is right, that's our historical analog standard they're articulating here. If they share a common why and how, they must both, one, address a comparable problem, that's the why, and two, place a comparable burden on the right holder, the how. So it has to be like, we want to keep dangerous people from carrying. Okay, great. That's the same why. The how, we do that by restricting drug users. We do that by restricting, criminals, right? And here, the government, in something that should probably piss off anyone out there who is a user of marijuana, the government basically says, well, if you smoke marijuana, you're like, it's
You're
like
mentally ill.
You're mentally ill. Like this stands up.
Reefer madness.
Yeah, exactly. Like this stands up through the historical tradition of not letting the mentally ill carry because we institutionalize them, which like,
Sure.
I don't smoke marijuana. You know me.
Good job, government lawyer.
I'm square as anything, but that's a stretch.
Yeah, no, it really is. So, I really like this analog breakdown. I think it's easy enough for the government to, when you make the test this easy and the government fails, it just makes it so apparent that, hey, look, you really didn't meet your burden. Sometimes they create these like factoring tests and it gives them all these extra little wiggle rooms. But by making the test so simple and so straightforward, and if you can't meet the test, well, guess what? I think that really bolsters kind of the arguments behind, hey, this is really not a historical analog. This is really not something that you can impose on the Second Amendment, infringe on people's rights. And so I really, really like that. But going back to our case that we started with, Gill, all right, government's going to appeal this case. Did that judge abuse its discretion? Well, the court that it's about to land in is this just issued this Daniels decision just 2 days ago. And so I don't think that it's an abuse of discretion.
No, and I don't think it will be found to be an abuse of discretion. However,
yeah, we got those separate issues.
Yes. What does this mean for all of you out there? Does it mean you get to smoke 2 joints in the morning, smoke 2 joints at night, and then grab your gun? No. Hold on. Because this is not, as we were talking about earlier, a facial challenge. This is an as-applied challenge, meaning anybody else out there is going to get arrested, and you're going to have to make an as-applied challenge.
Yeah, so I'll say the government's going to have the burden of showing dangerousness.
Right. Oh, yeah. No, the government's going to lose.
Right.
But they're still going to get you.
They're still going to get you. And so it doesn't keep you from, the statute's not unconstitutional. It doesn't keep you from getting arrested, dragged into the system. We see the bar just got raised, I would say, significantly for the government. This isn't just read the law and, all right, you check the box. It's a read the law, and the court has added some things here that the government needs to prove in order to demonstrate that the law is constitutional as applied to the person, the subject of the investigation, the target of the criminal prosecution. And I'll say they're going to have an uphill battle, but the law's still there.
The law's still there. And, ideally, in our perfect world, the government says to themselves, at least in the Fifth Circuit, the law is decided, and we don't arrest people for this anymore unless we can prove that they're dangerous, unless we can prove that they were actually intoxicated whilst carrying when we arrested them. In a perfect world, you guys all know how perfect the federal government is, so we'll see.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question and comment below. What do you think about these cases? Do you think you should be able to smoke and carry? Until next time, we're the Arms Attorneys.